Good morning, everyone. Thanks, Greg. And welcome, everyone, to today's Drugs Don't Work in New Jersey webinar, Marijuana in the New Jersey Workplace, a focus on workers' compensation. Today's speaker is Matthew Gitterman, a partner at B&D in Edison, New Jersey. Matt Gitterman argued in defense of the employer in Hager versus M&K Construction, a landmark case that was brought before the New Jersey Supreme Court dealing specifically with the issue and use of marijuana by an employee. He'll provide specific insight on the issue of workers' compensation and marijuana use. And before I turn it over to Matt, I just want to make note that in light of the recent New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act that was signed into law by Governor Murphy, the Partnership for Drugs for New Jersey will continue to keep members updated on this important issue and provide updates, and that the Drugs Don't Work in New Jersey toolkit is currently undergoing a revision to provide updated information on policies and procedures related to the law to assist you in maintaining a healthy, safe, and drug-free workplace. As further revisions occur, you will be notified. I now turn the event over to our expert and speaker for today, Matthew Gitterman. Thank you so much, Matt, for being with us today. We look forward to hearing from you.
Thank you, Angela. This is Matt Gitterman. I really appreciate, good morning, everybody, and I really appreciate you giving me the opportunity to address everyone this morning. Just a little background. Biancamano and Di Stefano, B&D, is a defense firm. We defend all sorts of cases. Personally, I have defended workers' compensation claims for over 30 years now. That's all I do. I only defend workers' compensation cases in New Jersey. And so my perspective today is just a workers' compensation perspective on marijuana. And I say that with a grain of salt because I went to law school because in college and in high school, I realized I really didn't have a very strong aptitude for science. And I became a workers' compensation attorney. And of course, being a workers' compensation attorney, I've learned a tremendous amount about medicine, so science, and now marijuana through the Hager case. So despite the fact that I didn't think I had an aptitude for science, it's really been forced upon me, and I've enjoyed it. So with that said, I just want to give you a little background. Actually, I need to give you a lot of background because there's a lot of moving parts with the Hager case and in helping me explain the Hager case. So I just want to give you a little background first on workers' compensation in New Jersey, and just a little bit of trivia. I normally, if I'm doing the presentation live, I can look at people and they can answer this live, but maybe you could do this through the chat. The New Jersey workers' compensation system was enacted in the early 1900s, 1911 to be exact, and it was signed into law by a governor of New Jersey that later became president of the United States. Can anybody name that president? So I'll give you a second to type out if you want to into the chat. Oh, somebody's got it. Okay, good. So yes, Woodrow Wilson. No, it was Woodrow Wilson. Woodrow Wilson was the governor of New Jersey and later president of the United States, and he signed the New Jersey Workers' Compensation Act into law on April 4, 1911. Just a little bit of trivia. The workers' compensation system in New Jersey is similar to the workers' compensation systems in other states. There are obviously some changes, but in workers' compensation in New Jersey, there are 3 benefits that are available to a claimant or to an injured worker. 3. The one benefit is wage replacement. We call that temporary disability benefits in New Jersey. And if you're out of work as the result of a work injury, and the doctor keeps you out of work, the authorized treating doctor keeps you out of work, you're entitled to wage replacement benefits, and those benefits are paid at 70% of your salary up to a statutory maximum, which changes every year. There's a waiting period of 7 days, and then after that, it can actually extend for 400 weeks. which is not usual. Usually people, if they're out of work, they're not going to be out of work for that long. Although Mr. Hager was. Mr. Hager was out of work for a long time, but we'll get into that. Second benefit, and I'm really doing this out of order because I want to get into the third benefit, which is what we're going to be talking about today. But the second benefit that's available to an employee in workers' compensation is permanency benefits. And what that is it's compensating an injured worker for their permanent impairment. And in New Jersey, that is all scheduled. It's pursuant to statute. I don't know if any of you have heard of the workers' compensation chart, but that's how we determine the permanency that an injured worker is entitled to or not entitled to. That's the second benefit. The third benefit, which is the benefit that we're really going to be focusing on, and actually, let's go to the next slide. The third benefit is medical treatment. Medical treatment, Section 15 states the employer shall furnish to the injured worker such medical, surgical, and other treatment and hospital service as shall be necessary to cure and relieve the worker of the effects of the injury and to restore the functions of the injured member or organ where such restoration is possible. Now, what does all that mean? Let's back up for a second. One of the great things about the New Jersey workers' compensation system as compared to other states is the fact that in New Jersey, the employer controls medical treatment. Now, in some states, the employer has to provide a panel of doctors and the employee can then choose which doctor or doctors that they go to off the panel. In some states, the employer has control for a certain period of time. And then after that, the employee is permitted to secure treatment on their own. In New Jersey, the employer has the right to control medical treatment. And that's really a very important thing in New Jersey because it allows New Jersey to, relatively speaking, keep its workers' compensation costs down. And you know, the statistics vary from year to year. Those of us that practice in the workers' compensation system like to think that we're very competitive with other states, but of course, with the cost of medical treatment going up and up in this country, that remains to be seen. It changes, but if the employer uses that right to control medical treatment in an appropriate fashion, they can really limit their costs. So that's the third benefit of workers' compensation. And why don't we go to the next slide? And when we're talking about medical treatment in workers' compensation, and particularly in this context of the Hager case, palliative treatment is required by employers where it will relieve symptoms and improve or maintain function. And I can't tell you how much I get into arguments in court involving curative treatment versus palliative treatment. Curative treatment is required in workers' compensation. Generally speaking, palliative treatment is not. The Hanrahan decision is an exception. And the Hanrahan decision holds that palliative treatment is only required in situations where it's a really significant injury. And so to give you an example, if you have somebody that has a back sprain and they're diagnosed with a back sprain, maybe there's an MRI done, maybe it shows nothing, maybe there's no MRI done because no MRI is necessary. In that instance, most likely, a judge is not going to require an employer to provide palliative treatment being pain management treatment, chiropractic treatment, any number of modalities that might be considered palliative. So That's an important distinction. Obviously, when we're talking about a more serious injury, and in order to keep pain at a certain level and to keep an injured worker at or improving their function, then palliative treatment is required. And unfortunately, that was the situation in the Hager case. I just want to back up again and give you a couple of more background statutes that I'm going to mention today in the discussion of Hager. First of all, obviously, we have something called the Federal Controlled Substances Act. I may refer to it today as the CSA. The CSA, it's 21 U.S.C. 801, and it establishes a federal scheme for drug control and enforcement. Congress classified substances, drugs, into 5 schedules based on the potential for abuse, the existence or absence of their accepted medical use, the risks they pose when used under medical supervision. And as you're probably aware, marijuana is classified as a Schedule 1 drug. It's been classified that way from the beginning, and it remains classified that way. And when I say it remains classified that way, we will get into that as well. But marijuana is a Schedule 1 drug. And specifically, the CSA makes it a crime to manufacture, distribute, or dispense or possess with the intent to manufacture, distribute, or dispense marijuana, knowingly or intentionally. And obviously, you cannot possess a controlled substance. Criminal prosecution can be brought against a principal who commits that offense, but also, and this obviously applies to the Hager situation, the CSA provides that a criminal prosecution can be brought against anyone that aids or abets or willfully causes the commission of the crime. Now, it's interesting, the CSA also does talk about conflicts that might arise between state and federal law. I'm quoting from the CSA: "No provision of this subchapter shall be construed as indicating an intent on the part of the Congress to occupy the field in which that provision operates, including criminal penalties to the exclusion of any state law on the same subject matter which would otherwise be within the authority of the state, unless there is a positive conflict between that provision of this chapter and that state law, so that the two cannot consistently stand together." That's kind of important. Unless there is a positive conflict between that provision of this subchapter and that state law, so that the two cannot consistently stand together. That's the provision that permits states to establish their own medical marijuana acts in this situation. And that gets us into New Jersey's Medical Marijuana Act, which is obviously important. Yeah, I'm sorry, somebody just asked. A Schedule 1 is the worst possible, classification. Schedule 5 goes up. It's not as bad. Just to give you an example, when you're talking about a Schedule 1, we have marijuana. When you're talking about opioids, opioids are classified as Schedule 2. So that's sort of interesting. When you're talking about New Jersey's Medical Marijuana Act, you have to keep in mind that it's been changed quite a bit over time. Believe it or not, I started trying the Hager case. Hager testified for the first time in 2016. So when he testified in 2016, the Medical Marijuana Act was a little bit different than its current composition. And at that time in 2016, New Jersey's Medical Marijuana Act was very specific about the conditions that could be utilized for a patient that would require medical marijuana. And specifically, it limited those conditions to seizure disorder, including epilepsy, intractable skeletal muscular spasticity, or glaucoma. There are some other, cancer, sclerosis, muscular dystrophy, Crohn's disease, inflammatory bowel disease were also mentioned. But at the time that this case was litigated, chronic pain was not specifically indicated. It is now. So that's something just to keep in mind as I go through what I'm going to go through. All right, so let's talk about Vincent Hager a little bit. Let's change to the next slide, please. Just to give you a little background, I don't know how familiar everyone is with workers' compensation and how it works. As a defense attorney, I have a regular list in each county, and on a particular day, the workers' compensation system works on cycles. So on a particular day of the cycle, it's a 3-week cycle. On a particular day of the cycle, I'll have a regular list, in this case in Mount Arlington, and in this case with Judge Kowalczyk, who decided the Hager case. Judge Kowalczyk has recently retired, but I did have a list with Judge Kowalczyk for a number of years. And what happens is I'll have 30 cases on the list. So in normal times pre-COVID, I would go to Mount Arlington, I would conference all of those 30 cases. Some of them would need to be tried. Some of them were being settled. Some of them were just discussed. And in this particular instance, workers' compensation trials are bench trials. There is no jury. So at the end of the day, Judge Kowalczyk is the trier of fact. He presides over the trial, and he decides the trial, and he provides commentary as we go along. Because we try it on a cycle basis, it's not a traditional trial where witness after witness would testify one after another. The way it works is the first time the case is listed for trial, Mr. Hager would testify. In this case, he actually testified more than once. And that would, each time it may occur 3 weeks, then 3 weeks, then 3 weeks. And sometimes there are reasons for putting it off longer. And then after he testifies, you would have lay witnesses testify. There were no lay witnesses in this case. And then after that, you have medical testimony. And in this case, there were actually 4 doctors that testified. So the trial actually went from 2016 to 2018. Just to give you a little background, Judge Kowalczyk was known to be an extremely difficult judge. He was wanted to be involved in everything, was extremely liberal when it came to compensability issues. But I actually found him to be somewhat middle of the road when it came to deciding how much somebody was entitled to. So if I argued that somebody wasn't entitled to anything, he would always be against me. But if I argued that somebody was entitled to something, but maybe a little less, a lot of times he was on my side. But in the grand scheme of things, I believe that when Vincent Hager testified, and he testified for the first time on November 3, 2016, I believe that Judge Kowalczyk, by the way, when he first testified, his attorney didn't tell me that he was on medical marijuana. I don't think his attorney knew that he was on medical marijuana. So when he first testified, this took everyone by surprise, which is sort of interesting. At any rate, Vincent Hager was about 28 years old when he was injured on August 21st, 2001. He was a construction worker. Didn't really have, I mean, went to high school, no college, was not, really an educated individual. He had worked construction for most of his career prior to that. He was in a basement, what had been dug out to be a basement, and a concrete truck came to pour concrete into the basement. There was apparently a miscommunication, and the concrete truck dumped concrete right on Mr. Hager, causing him to fall down. He kept trying to get up, and he injured his back. Let's, next slide, please. Mr. Hager testified that he immediately experienced lower back pain that radiated down into both legs. He described it as shooting and stabbing pain. He initially sought out care with a chiropractor. The chiropractor sent him for an MRI. The MRI revealed a large disc herniation at L5-S1. The MRI indicated that the herniation caused central canal stenosis. It also revealed, the MRI also revealed disc bulging at the L4-5 level. The chiropractor referred petitioner to a neurosurgeon. There was a delay in Hager's treatment. He did not have insurance. The insurance company did not accept the claim initially. I wasn't involved at this point. This is long before my involvement occurred. So it was a number of years. It was actually 2003 when he came under the care of a neurosurgeon, Dr. William Klempner. And ultimately, he had a lumbar laminectomy with Dr. Klempner in November of 2003. It was a lumbar laminectomy and decompression. Unfortunately, the surgery was not successful because following the surgery, Mr. Hager still complained of a significant amount of pain. In September of 2004, he had an EMG, revealed extensive nerve damage. Dr. Klempner recommended a spinal fusion. That never occurred. There were some intervening health issues going on. He stopped treating for about 2 years, started treating again in 2006, was seen by an orthopedic surgeon, a Dr. Ben Yashay. The doctor recommended a lumbar fusion also. But Mr. Hager at that point decided not to undergo additional surgery and came under the care of a Dr. Jonathan Lester, who was at Dr. Ben Yashay's office, and unfortunately started to receive oxycodone. So that oxycodone started in 2006. It continued in 2008. Mr. Hager came under the care of a Dr. Legerio. Dr. Legerio's treatment was paid for by Medicaid. Again, Dr. Legerio prescribed oxycodone, OxyContin, and ultimately referred Mr. Hager to another neurosurgeon, a Dr. Nosko, N-O-S-K-O. Dr. Nosko ultimately performed that previously recommended lumbar fusion. It was a 2-level lumbar fusion in September of 2011 with cages. Mr. Hager initially said he got better. He did wear a back brace for a year. He underwent extensive physical therapy, but the pain started to come back, and he came back under the care of Dr. Legerio. Dr. Legerio again started prescribing opioid medication. When petitioner testified, I refer to Mr. Hager as petitioner, that's what we call them. When he testified, he indicated that he was prescribed OxyContin, oxycodone, Valium, Lyrica, and Dr. Leggerio was diagnosing him with chronic debilitating pain. Okay, let's change the screen. Perfect. Mr. Hager testified November 3rd, 2016. He testified January 5th, 2017. As I said, his attorney, Victor Matthews, who actually is a very good attorney, was not aware that Mr. Hager was on the medical marijuana when he testified. When he testified in November of 2016, he indicated that he had come under the care of a Dr. Joseph Liotta in April of 2016. Dr. Liotta was ultimately the doctor that testified, or one of the doctors that testified on Mr. Hager's behalf. Dr. Liotta diagnosed the chronic pain syndrome. He also diagnosed the spasticity as per the MMA guidelines, and he put the petitioner on medical marijuana. He got the petitioner qualified for medical marijuana pursuant to the MMA. And this is sort of interesting. Several of the courts, the judge, the appellate division, when they decided this case, they mentioned that Dr. Liotta prescribed marijuana. Well, that's not accurate. You cannot prescribe marijuana because it's a Schedule I drug. The Medical Marijuana Act does not mention the word prescribe. It's more of an authorization. So Dr. Liotta authorized Mr. Hager to get the medical marijuana. When he testified in the case, Hager said that it actually improved him. He was feeling better because of the marijuana. He testified that although he had chronic pain, starting in his lower back and going down both of his legs, the pain varied from a dull aching to a stabbing pain. The pain affected his activity of his daily life. He could only stand for half an hour at a time. He was better when he was lying down. And he testified that he was unable to work, and as a result of that, he was living with his parents. By the way, he was living with his parents when this accident occurred. So, and the other thing that was sort of interesting, and I really cross-examined him quite a bit about it. He testified that he was able to regularly 3 to 4 times a week drive to a wooded area near his home and walk his dog for about 45 minutes, 3 to 4 times a week. Never admitted to me that he was smoking the marijuana in the woods, but I suspect that was what was going on. That was his testimony. Let's change the slide. After he testified, a Dr. Skolnick testified. That was Hager's orthopedic expert. Dr. Skolnick testified that Hager was totally and permanently disabled as a result of the injury. The doctor did indicate that a portion of that total and permanent disability was related to the opioids. He didn't mention medical marijuana because at the time that Dr. Skolnick evaluated Mr. Hager wasn't on the medical marijuana. I cross-examined Dr. Skolnick, and I said to Dr. Skolnick, look, I'd like you to assume, by the way, this is what we do when we cross-examine medical experts. We have them assume facts and then ask them questions about that. So I had him assume that Hager testified that the medical marijuana was helping him a little bit. Would that change his opinion on whether Hager was able to work or not, whether he was totally and permanently disabled or not? Very interesting, because Dr. Skolnick kind of fought me on that for a while and initially said, I don't think the medical, he said, Skolnick said, I don't think the medical marijuana can help you. In my experience, medical marijuana doesn't help you. But I pushed, and ultimately he said, well, if he testified that the medical marijuana is helping him, then I would say that he's not totally and permanently disabled. So that was sort of interesting. Dr. Gallick, Gregory Gallick, testified orthopedically on our behalf. Dr. Gallick estimated a disability of 12.5% of partial total. So he was saying that there was some disability, but Hager was able to work. Dr. Leota testified on behalf of Hager, and I'll get into a little more detail about that. And I had a Dr. Robert Brady, who was a pain management specialist, testify on behalf of, on behalf of the employer. And Dr. Brady, testified that marijuana was not appropriate, and we'll get into that a little bit more. I just wanted to go back for a second. When Hager testified, he said, the pain is never going to go away, but the marijuana helps to take the edge off the pain. It helps when the muscles spasm and they lock up. It helps to relax those muscles. So simply put, it reduces the pain and it takes the edge off the pain. So Dr. Leota tried to reason with Judge Kowalczyk and with me, and try to argue that even though the actual diagnosis was chronic pain, it was spasticity that qualified under the New Jersey MMA. Unfortunately, Judge Kowalczyk did buy that argument. Dr. Brady testified that Hager did not have a condition that qualified for medical marijuana under the New Jersey MMA. Unfortunately, Judge Kowalczyk did not agree with that argument. Judge Kowalczyk awarded Hager 65% of partial total. He apportioned that 50% to the orthopedic residuals of the back injury and the 2 surgeries, and 15% to the residuals from medical marijuana, which is sort of interesting. So I know we don't care about that, but I did win the case in the sense that Hager was not awarded total and permanent disability, but I lost the case because Judge Kowalczyk ordered my client, M&K, to provide Hager with medical marijuana. Now, I want to read you what Judge Kowalczyk specifically said. The respondent shall, within 10 days, contact Dr. Leota to secure his services as the authorized treating physician for Vincent Hager and provide a mechanism for reimbursement to Mr. Hager for the cost of his medical marijuana effective immediately. Copying counsel. Okay, I'm not going to get into that. So the point is, when I provide workers' compensation medical treatment on 99.9% of my cases, my clients pay the providers directly. My clients pay the pharmacies directly for the medications. In this instance, Judge Kowalczyk was trying to get around any federal preemption arguments that I would have, and obviously I advanced, by ordering me to reimburse Hager for the medical marijuana as opposed to paying the dispensary. So that's kind of an important distinction. I argued the case, we appealed Judge Kowalczyk's decision. I argued the case before the New Jersey Appellate Division, and unfortunately, the Appellate Division decided the case on January 13th, 2020, and I lost. And I'll get into that in a little more detail. And just to kind of update you, I did argue the case in front of the New Jersey Supreme Court on December 1st, and we're waiting for the decision. Let's change slides. My arguments in the Appellate Division, my arguments in the Supreme Court were, and actually, I mean, really federal preemption was my main argument, but I'll get into that last. Obviously, the argument of Dr. Leota versus Dr. Brady, the argument of whether medical marijuana is an appropriate treatment in this case. The other argument that I advanced is that the MMA, New Jersey's MMA, specifically provides that health insurance providers are not required to provide medical marijuana. I argued that a workers' compensation carrier or employer acting in or under the New Jersey workers' compensation system is essentially the same as a health insurance carrier. Judge Kowalczyk and the appellate division did not agree with my arguments. The last argument, which to me is the most persuasive argument, is obviously the federal preemption argument, and specifically that because medical marijuana is, because marijuana is illegal federally, a New Jersey state judge does not have the ability to require an employer to provide that type of treatment. The appellate division, for the most part, knocked down all of these arguments. The federal preemption argument, for the most part, they knocked down under the theory that by reimbursing, by having Judge Kowalczyk use the language requiring my client to reimburse Hager, they were not actively participating in the crime, that it was a completed act by the time we reimbursed Hager. Now, there's case law that says that if you're reimbursing somebody for the drugs, you're just as guilty. So they ignored that federal case law. That was brought to the attention of the New Jersey Supreme Court. Quite frankly, I don't have a lot of confidence in the fact that the New Jersey Supreme Court is going to find our way. I was asked quite a few questions, and some of the, let's change slides one more time. Some of the slides that you'll see that I'll go through contain some of the questions, some of the better questions that I was asked by the New Jersey Supreme Court. And I, for the most part, we were kind of at an impasse. The Supreme Court justices, some of them seemed to agree with me, a few, at least that's the way it seemed in the oral argument. But for the most part, I was getting quite a few questions. Well, what if a state court judge enters an order? How can the federal government prosecute your client? And I politely responded by saying, it doesn't matter that a state court judge enters an order. If my client reimburses Hager for marijuana, my client is aiding and abetting in the commission of a federal crime. Some of the other questions, and you can change the screen. Some of the other questions I got, essentially, well, the federal government is never going to prosecute your client for doing this. And I said, you may be right. They may not. But the fact is, I can't control, whether President Trump, is the president, President Biden is the president, or even, Obama before that. I can't control what the federal government decides that they're going to prosecute. And the fact is, and in this case, it's sort of interesting, and I did raise this issue also. My client is M&K Construction, but the insurance carrier is actually a Pennsylvania-based insurance carrier. So in reimbursing Hager for medical marijuana, which we haven't done yet, we actually have a stay of that, we would be sending a check from Harrisburg, Pennsylvania into New Jersey over state lines, which again also subjects them to potential federal prosecution. Those are some of the questions that the the Supreme Court asked me. It was a very interesting argument. I will tell you also that it's sort of interesting, but when I argued the case, there was recently a decision in Massachusetts. It's called Daniel Wright's, WRIGHT''S case, that was decided by the Massachusetts Supreme Court. Let's change the slide. It was decided by the Massachusetts Supreme Court, and it quoted the legal landscape involving medical marijuana for workers' compensation as being a, quote, hazy thicket. And in Massachusetts, the Supreme Court actually found our way. They found that their MMA, Massachusetts MMA, and the language contained in their MMA did not permit them to require an employer to provide marijuana as treatment. Now, prior to that, there were two Supreme Court decisions. Maine found similarly to Massachusetts, and New Mexico, unfortunately, found on the part that, well, against us, that medical marijuana is permitted in workers' compensation. I've seen New York, not the New York Supreme Court, but lower courts in New York have required medical marijuana. Courts in Connecticut, Minnesota have also required medical marijuana. Aside from Massachusetts and Maine, I haven't seen any other courts that have come out with respect to this. But this is a new area, and let's go to the next slide, which is really this is the last slide. Where do we go from here? Will President Biden and the current legislature legalize marijuana? That's the question, because quite frankly, if marijuana is legalized and taken out of the Schedule I classification, my arguments go away. If President Biden, if the legislature does not legalize marijuana, if it remains as a Schedule I, theoretically, if the New Jersey Supreme Court affirms the decision, I'm going to ask my client whether they would be interested in pursuing this to the U.S. Supreme Court, because it is a federal question. I've heard a number of prognosticators speak on whether marijuana will be changed federally. Some people think that it will, some people think that it won't. The people that think that it won't point to the fact that it was not changed under Obama, and point to the fact that it's possible that because Obama and maybe Biden had ties to drug manufacturers, that produce opioids, that they do not. There's an interest not to make marijuana legal federally. That remains to be seen. That's my presentation for today. My email should have been on the first slide. Don't hesitate to email me, call me if you guys have questions, or I'll certainly take questions now.
Thanks so much. Before we get to questions, I just want to mention that an evaluation and poll is going to be launching on the screen right now, so we would appreciate any kind of feedback that you can provide. We have a few questions, but can you speak a little bit more about how the federal law and the state law interact, and how the federal law would preempt? I know you spoke about it at the end, but could you add a little bit of information and clarification to that?
Yeah, I mean, it's sort of interesting, and I'm just looking now. I wasn't looking at the some of the questions, but I'm looking at some of the questions now. I mean, one of the other things, there is actually a bill right now that would specifically require employers to provide medical marijuana in New Jersey. It's a New Jersey bill. But to answer your question, I mean, the preemption argument, the supremacy clause of the United States, which is contained in the Constitution, essentially holds that if there is a conflict of laws between federal and state law, that federal law determines, the course of action. And specifically in this instance, I would contend that there is a direct conflict between the federal CSA and the state MMA, because if a drug is classified as a Schedule 1 and cannot be used for medical purposes, the state obviously disagrees with that. And in this instance, by requiring the employer to provide something that is illegal federally, they're asking the employer to commit a federal crime, and they're asking the employer to violate federal law. That's where the conflict is.
All right, great, thank you. So does an employer have the right to dismiss an employee if they come to work high, or not if it's authorized by a doctor for use of marijuana?
Yeah, so that, I mean, I'm not an employment lawyer. And I believe that that area of law is still being determined, but I believe that there are now requirements in state law that employers recognize employees that are authorized to take marijuana through the MMA, and in those situations, depending upon the job, may require an employer to accommodate the employee. And again, that depends upon the job. And again, that's also for medical marijuana. If an employee comes to work high, an employer has a policy and the employee is high because of recreational marijuana, I think that's a completely different situation. And that, then allows, from what I believe, the state law is currently allows an employer to terminate or discipline an employee in that situation. But that's, unfortunately, because marijuana, particularly recreationally, is so new, that's a developing area of the law. And I presume in the next, 6 months to a year, there'll be a lot of cases that address those issues.
All right, thanks so much. And so what would you recommend employers should be doing right now with the current status in New Jersey on medical marijuana?
I think that obviously from a workers' compensation standpoint, unfortunately, it looks like this is going towards requiring employers to provide medical marijuana in certain circumstances. I think employers should be aware of that. But obviously, when you're talking about marijuana, recreational marijuana versus medical marijuana, you need to look at your employees. If you have an employee that tells you or advises you that they're in the medical marijuana program, then I think I would probably advise you to seek counsel, legal counsel, to determine what your rights are and what accommodations, if any, you are required to make. And that, again, depends upon the job that employee is doing. That depends on a lot of other factors involved in your particular workplace. But I think that employers need to be mindful of this. They need to be mindful of the fact that now, under the recently enacted legislation, marijuana is legally recreationally in New Jersey, as in a number of other states. And I think employers need to, create policies for this. And in order to do that, I would highly recommend that you discuss that with, employment attorneys that are doing that. I know in my office, we are doing this for a number of employees. And it's unfortunately, this is where the world is going, and it's only going to get worse.
All right. Well, that's our last question, and it's a good segue into our next event, which is that on May 3rd, we're hosting a Drugs Don't Work in New Jersey webinar, Marijuana in the New Jersey Workplace, What Now? And we'll have a series, we'll have a panel of attorneys who will take your questions. So there's a link right now in the chat feature, and you can sign up for that, and we'll be accepting questions in advance to provide our attorneys and on the day of that event, which is May 3rd. So Matt, I want to thank you so much for your presentation today. It was extremely informative, really great perspective on the issue of workmen's compensation, and we appreciate your time with us today.
Thank you very much.
I also want to thank.
My pleasure.
Yes. I also want to thank all of our attendees. If you haven't had a chance, please complete the poll. Thank you for being with us today. We'll be sending you an email after this event with a link to the slides as well as a recording of this presentation. So thank you again for joining us, and be well. Have a good day, everyone.